Equal protection. Here's our first rule. The Supreme Court construes the Equal Protection Clause to mean that all laws must treat similarly situated persons equally. Rule number 1, the Supreme Court construes the Equal Protection Clause to mean what? All laws must treat similarly situated persons equally. Rule 2, if a law infringes on the rights of a class of persons, the court will look to the nature of the class, then review the challenged law based on one of 3 levels of scrutiny. All right, whole rule. The Supreme Court construes the Equal Protection Clause to mean that all laws must treat similarly situated persons equally. If a law infringes the rights of a class of persons, the court will look at the nature of the class, then review the challenged law based on one of 3 levels of judicial scrutiny. Okay, let's go through the whole thing. This is the if you have time rule. The 14th Amendment provides that no state shall deny any person within its jurisdiction the equal protection of the laws. The Supreme Court construes the Equal Protection Clause to mean that all laws must treat similarly situated persons equally. 3, if a law infringes the rights of a class of persons, the court will look at the nature of the class, then review the challenged law based on one of 3 levels of scrutiny. Let's repeat that whole thing again. 1, the 14th Amendment provides what? No state shall deny any person within its jurisdiction the equal protection of the laws. 2, the Supreme Court construes, that's right, the Equal Protection Clause to mean what? All laws must treat similarly situated persons equally. And 3, if a law infringes the rights of a class of persons, the court will look at the nature of the class, then review the challenged law based on one of 3 levels of scrutiny. Okay, we have beaten the 3 levels to death, so we're not going to cover them here. Just remember, strict scrutiny, burden on the government, narrowly tailored to a compelling interest, and applies to suspect classes, race, religion, national origin, and fundamental rights. For example, denying aliens welfare. Intermediate scrutiny, substantial, important, gender, non-marital children. If it's gender, the government has to show what? Oh yes, an exceedingly persuasive justification for the discrimination. That comes to us from VMI. And rational basis review. The burden is on the challenger to prove the law is not rationally related to any legitimate governmental interest, and thus a law will generally be upheld unless it's arbitrary or irrational. Okay, let's go through our sub-rules. States and the federal government can discriminate against aliens under rational basis review. Repeat, states and the federal government may discriminate against who? Aliens. Under what? Rational basis review. In what? Government employee, security, and public policy. Government employment, security, and public policy. Let's repeat the whole rule. States and the federal government may do what? Discriminate against who? Aliens under rational basis review in government employment, security, and public policy. Okay, what are we talking about? Police officers, of course, firefighters, public school teachers, serving on jury, being a probation officer, voting, being an FBI agent. Okay, why can the federal government discriminate against aliens? Because Congress possesses plenary power over immigration. Why can they discriminate at the state level? Because these jobs are government functions. They are at the heart of a representative government, or they affect public policy. A police officer, a probation officer, government function. Serving on a jury, public policy. Being a political candidate, heart of a representative government. Okay, and our other three are affirmative action, quotas, and set-asides are presumptively unconstitutional. Affirmative action, quotas, and set-asides are presumptively unconstitutional. That's our general rule. What's unconstitutional? Affirmative action, quotas, set-asides. There's only one narrow exception, and that's if the law is designed to remedy past discrimination. But that's unlikely. Okay, what's our rule? The court has held that affirmative action, quotas, and set-asides are presumptively unconstitutional. Okay, let's talk about non-marital children here for a second. Remember, we need that exceedingly persuasive justification for gender. Non-marital children must be treated as marital children if what? They've been acknowledged, or two, they have established paternity. And what does this apply to? We have case law that non-marital children who are acknowledged or established paternity can obtain inheritance rights, can't be denied public benefits, and they're entitled to a portion of wrongful death claims. Okay, non-marital children, if they have been acknowledged or established paternity, must be treated as marital children for the purpose of what three things? That's right, wrongful death claims, 2, inheritance, and 3, public benefits. Our final rule script deals with political candidates. The government may place reasonable burdens on political candidates, such as fees, ballot requirements, and a disclosure of their financial connections to people who have an interest in their candidacy. The government may place reasonable burdens on political candidates, fees, ballot requirements, and financial connections to people that have an interest in their candidacy. Okay, let's try to repeat the equal protection full rule. I'm going to give you a start. It starts with the 14th Amendment. The 14th Amendment provides that no state shall deny to any person within its jurisdiction the equal protection of the laws. The Supreme Court construes the Equal Protection Clause to mean that all laws must treat similarly situated persons equally. If a law infringes on a class of persons, the court will look at the nature of the class and then review the law under one of 3 levels of judicial scrutiny. And we know what those are. Okay, that's it.